The atmosphere inside the Capitol hearing room was thick with anticipation. Reporters shuffled in the press section, cameras hummed softly, and political aides whispered to their bosses, passing last-minute notes. At the center of it all sat Judge John Roberts, the Chief Justice himself, looking every bit the embodiment of judicial authority, polished glasses, calm expression, and a confidence that came from decades of commanding the highest court in the land. On the other side of the table, Congresswoman Jasmine Crockett leaned back in her chair with a half-smile, her notes neatly stacked. Known for her sharp legal mind and a debating style that could slice through the thickest political spin, Crockett was no stranger to tense exchanges. But today's confrontation was different. It wasn't just about policy, it was about intellect. The hearing had been called to address judicial ethics and the limits of Supreme Court influence. Crockett had spent days preparing, combing through past opinions, dissenting arguments, and inconsistencies in Roberts' statements. She knew the Chief Justice prided himself on quick thinking, but she also knew that confidence sometimes came with blind spots. The opening exchanges were polite, almost cordial. Roberts explained the court's recent controversial decisions with the precision of a man used to being unquestioned. But Crockett's eyes narrowed slightly. She wasn't here for rehearsed answers. "Chief Justice," she began, her voice firm but measured, "you've said in previous remarks that the judiciary's role is to interpret the law without bias. But in your last term, you voted in ways that contradicted precedent on 3 separate occasions, despite calling yourself a guardian of precedent. Can you explain that contradiction?" Roberts adjusted his glasses, clearly ready with a rebuttal. "Congresswoman, the court must sometimes adapt precedent to the evolving context of law. My votes reflect careful legal reasoning." "Careful reasoning," Crockett interjected smoothly. "Or selective reasoning. Because in Benson vs. Holloway, you ignored the exact precedent you cited as binding in Porter vs. Gaines just 2 years earlier. That's not evolving context, that's intellectual inconsistency." A ripple went through the audience. Roberts paused for a beat, visibly taken aback by the precision of her reference. He tried to pivot, but Crockett pressed harder. "You claim to champion textualism, yet you deviate when the plain text of the Constitution doesn't suit the outcome you prefer. Either the principle applies universally, or it's not a principle, it's a tactic. Which is it, Judge Roberts?" For the first time, Roberts' confident tone faltered. He leaned forward, trying to assert control of the exchange. "Congresswoman, with respect, you're conflating interpretive methods." "I'm not conflating anything," Crockett cut in. "I'm applying your own words to your own record. And the math doesn't add up." A murmur spread among the reporters. Roberts was frowning now, not because he didn't understand her argument, but because he did. The room's energy shifted. Crockett's questions came faster, each built on a documented quote or a direct case citation. Roberts began answering in shorter, more defensive bursts. He glanced toward the committee chair, perhaps hoping for an interruption, but none came. "You've often spoken about judicial restraint," Crockett continued, "yet your majority opinions have expanded federal power into areas that even your conservative colleagues warned against. How do you reconcile that with the very restraint you claim to uphold?" Roberts straightened his papers. "Congresswoman, you're taking my rulings out of their nuanced legal context." "Context," Crockett repeated with a raised eyebrow. "Let's talk about context. In Harrington vs. United States, you wrote, and I quote, 'The court is bound by the Constitution, not by convenience.' Yet 2 months later, in Vega vs. Coleman, you admitted convenience played a role in limiting the scope of Miranda protections. So, Chief Justice, which one is it? Bound by the Constitution, or bound by convenience?" Roberts opened his mouth to respond, but stopped. His jaw tightened. A hush fell over the room. Even the clicking of reporters' keyboards seemed to pause. 3 minutes. That's how long it had taken for Crockett to move him from smooth confidence to stunned silence. His carefully constructed persona, the unflappable, endlessly rational jurist, was cracking. When Roberts finally spoke, his voice lacked the earlier steadiness. "I would need to review those statements in their entirety before confirming they're yours," Crockett said, her tone icy but calm. "They're from your published opinions. No review needed." Laughter erupted from a few corners of the room, quickly hushed. Roberts sat back, the weight of the moment settling on his shoulders. He wasn't out of arguments, he simply no longer had the footing to deliver them. Crockett didn't gloat. She simply leaned forward, her voice soft but cutting. The law isn't a game of memory, Judge Roberts. It's a matter of consistency. And when the Chief Justice of the United States applies two sets of rules, one for when it suits him, and one for when it doesn't, that's not interpretation. That's manipulation. By the time the committee chair called a recess, Roberts looked drained. He didn't make eye contact with Crockett as he gathered his papers. The Chief Justice, who prided himself on being untouchable, had been publicly dismantled in less than 3 minutes, and everyone in the room knew it. Outside, as reporters swarmed her, Crockett kept her remarks brief. I'm not here to embarrass anyone. I'm here to hold them accountable. If that makes someone uncomfortable, maybe they should ask why. Meanwhile, Roberts' aides hurried him down a side corridor, away from cameras. The nation would debate the exchange for weeks, but inside that chamber, the verdict had already been delivered.